I may choose to hold slap suits until we get, because I know we all got a lot of emails and from different people, and before we start putting things out that is going to make nobody happy.
Okay.
We may.
You're all good.
Okay. Welcome back to the Judiciary's Civil Law and Procedure Subcommittee. We're going to continue, I think, where we left off. And let me see if I can pull up my list. We left off on 848. And I'm not sure we're going to vote on 848, but let's have some conversation about it. How do I get to this today? Oh, good. It's still up. All right. 848. All right. Let's try and do it this way. I'm figuring out if I can get online here. I finally got it. Okay. Prohibits the arrest or incarceration for failure to appear in court for an examination, the aid and enforcement of a money judgment entered in small claim court and district court, or to show cause why the individual should not be found in contempt for failure to appear in court for examination. So basically what the bill does is prohibits us from incarcerating people for failing to show up when they've been sued because they didn't pay their bills, and they're trying to collect. Is there? I think that there are some amendments that the chair emailed me earlier. Holly, am I correct in saying that there are some amendments that may be proposed, and he didn't think that we should vote on it yet because we may want to do the amendments in subcommittee. But I wanted to talk about the bill and see if there was any issues that anybody had with this bill before we go forward. I will say that this is the bill when I was incorrectly stating earlier that the collections bar and the consumer bar both agreed to. So from what I understand, they all agree. Are there any comments anybody has about this bill or concerns anybody has about this bill?
Can you tell me what the alternatives are? Like, how does this work?
So the way that this works right now is if somebody fails to appear, they've been sued. Let's say X, Y, and Z, Midland Credit, which is a big company that owns a lot of debt. They buy debt from credit card companies or from people from multi-housing apartment folks. They buy the person's debt. The person no longer lives there, but they have a judgment against them, or they don't have a judgment. They have a debt against them, and Midland buys the debt. Then they sue and try and get the person to either come up with a payment plan, or they sue and they try and get them they try and get a judgment against them. The individual does not appear in court. They want to figure out if the person has any money or any assets that they can figure out that they can attach, but they can't get the person to answer any questions. So they file an attachment or they file a some kind of motion to require the person to come in and testify. And if they fail to appear, the judge can send the sheriff out to go get them and bring them in to answer questions. And that's what we're talking about, is prohibiting the ability to incarcerate people who fail to appear.
What's the alternative to that? If this bill were passed, what, as a matter of technical, practical execution, what do you do in that case?
You would ask the court for a judgment based on the information you have. And then you would try, I mean, right now, what they try and do, many companies don't use these types of efforts. What they do is they try and garnish wages, garnish bank accounts. Remember the bill we were talking about earlier this morning about bank accounts that were attempting to be garnished. Garnish if they have a job, garnish their salary. And if they have a house or a car, get a lien against it. Those are the kinds of things that they would do, and not drag them in to make them answer questions like, because they want to, here's what they want to do. They want to find out, do they own property? Do they own a car? And they can't find that out. So they want the judge to make them come in and force them to get that information. That's my understanding of what's happening. I am.
Okay,
Let's see.
we've got a lot of hands up here.
All right, go for it. Who's got the first question?
Delegate Cox.
Well, I don't want to butt in, but just real quickly, I think the judiciary was against it, Mr. Chair. And this is not just for. Can you hear me?
Yep, I'm looking at their testimony right now. Go
Can
ahead.
everybody hear me?
Yes, we hear you.
Okay. Thank you, Mr. Chair. So I think the judiciary was opposed to this bill. And the reason is because it doesn't just address incarceration. It also addresses the judge's power to issue a show cause and force an individual to respond to a court order. And so there'll be no power for the judge to bring anybody into court under these circumstances. For instance, in an oral exam, in order to find out whether they have a car or a bank account or anything else that can be lawfully used to possibly help pay a judgment,
To satisfy the
you have to have, you have to have an oral exam, and if you can't bring them into the courthouse, you can't even have an oral exam.
Mhm.
So, I mean, I don't have a problem personally with the incarceration issue unless there's an open contempt of a judge, but I think the judiciary put in a letter something about the stripping them of the power to actually exercise authority with the court order was an issue.
Mm-hmm. Okay. Perhaps that is what the chairman is waiting on, is an amendment from the judiciary to, and that could be. However, the method contemplated in House Bill 40 effectively eliminates the ability for the court to enforce its orders by not allowing the arrest of an individual for failure to respond to a court order. That individual is essentially free to disregard the orders of the court with no repercussion. The bill would conceivably result in more persons failing to appear after a money judgment is entered against them in a small claims action. If the individual knows that they cannot be arrested or brought to court to enforce the judgment, there's no incentive to appear. Further, there is no consequence for the failure to appear if a person cannot be forcibly brought to court to show cause why the individual should not be held in contempt. So that makes sense. But if we're only talking about small claims collections cases, I don't know if we are. Is this only dealing with collections? Holly? Nicole, do you know that? You know?
Yeah, I think it's just dealing with enforcement of a money judgment. Yeah, small
Yeah.
claims.
Yeah.
So if it's only for small claims on money judgments, then there should be no reason to compel them to come in. They just have to issue I mean, I'm not sure why they have to be in court. What's the reason?
I can elaborate, Mr. Chair. I think typically what will happen is they will either, the plaintiff will either send interrogatories, like you said, to request information about their assets. And then if they fail to respond to those interrogatories, they may file a motion, either a motion to compel or a motion for contempt. And that's where this starts to come into play. Or they request an oral examination for them to appear in court to answer the questions, like you said earlier, but then they fail to appear at the oral examination. And because of their failure to appear, then they'll ask for order for contempt because the defendant failed to appear.
Right. So the question I have is if the association that represents these plaintiffs' firms is in favor of the bill, so they're not going to act on these. Why would?
Well, I would say in practice, I mean, I know especially Montgomery County, they're not even issuing these anyway currently. Like Montgomery County, Prince George's County, even they're not granting them currently or issuing them, but that's aside. I mean, I guess there's some jurisdictions that still are, and maybe that's the reasoning for the bill. But I mean, yeah, at the end of the day, I'm sure the plaintiff, they just want their money on the judgment. So
would it be? And again, I think we're gonna just hold off. I just wanted to hear what the subcommittee's thoughts are on this. But is there any thought on eliminating the show cause part of this and just having it be the incarceration part? Or are they so intertwined that you can't have one without the other? Go ahead, Delegate Malone.
I think they are intertwined. I mean, the concern I have is, let's say you have a $2,000 judgment, small claims. If we pass the bill saying that if you find a bank account, the first $2,600 is excluded, what somebody could do is they could set up 20 bank accounts with $2,500 in each of them. Every single one you would not be able to garnish. So somebody could have $25,000. They just keep a small amount in the different bank accounts. The problem is there's people that live off the grid and live cash only. And the only way to really get some real answers sometimes is the oral exam. I did one 20 years ago, and we were able to get the judgment paid because they own land in another state. And I'm not sure how you find out something like that without the benefit of an oral exam.
yeah. But
I got you, Delegate Brown.
And if they don't show up to the oral exam, they'll just learn don't show up. And the only way to get something is, to have, have them have to post a bond for failing to show up.
Yeah. Malone, I was going to say though, Delegate Malone, the $6,000 exemption is a one-time exemption. So under your hypothetical, if they have 10.
No, I didn't say 6,000. I said 2,600. That's
but right, but there's still a one-time exemption. So if they have 2,600, they use the $2,600 exemption. They can't go back and use it again subsequently. Is my point.
But that's not what the bill was.
If that bill were to pass, that's
And it doesn't say one time. The way I understand that bill, it's every single time if you garnish any bank, if it has less than $2,600, then you don't get to do the garnishment.
Per account, I believe it's per account.
It is per account.
Let's just take some more comments. Let's take some more comments. I know that we have Delegate Conaway, I think, wanted to ask a question, and Delegate Fisher and Delegate Kramer. So we have a lot going on.
Thank you, Mr. Chairman. So in the case of someone has someone lost a claim against them for $2,000, and you want to know where they have their money and they don't answer you, then you're going to say you want to be able to get a summons for them to have to come to court to answer and disclose what kind of assets they have? Well, right now we don't do that. Is that
That's what the current law is. That's the current law.
that we can issue the summons
Yes.
and come to court? And so what is this going to change?
This is going to say that you can't, basically.
You can't lock them up.
You can't lock them up. And
Well,
I believe, does it also say that you can't bring them into court? Can the sheriff bring them into court to make them answer questions? That's what my question was. If you can still, have the sheriff pick them up, bring them into court to answer questions without locking them up, or is it so intertwined that that's considered incarceration for the
Says
purposes?
may not be arrested.
So why are we trying to change this law at this time?
Because the reason is, and the Attorney General here, the Office of the Attorney General, so this is what they say.
I can help too, Delegate Cardin, if you want me just to explain the background a little bit.
Go ahead.
So some of the testimony, Delegate Conway focused on how body attachments are used in certain counties more frequently. So for example, in Prince George's County, Anne Arundel, Hartford, Howard counties, they were responsible for over 25% of the body attachments in the state. Whereas some counties just use wage garnishments or other type of property liens versus bringing the debtor into court, because it just leads to, in the testimony, it just leads to more debt collection. So
this is dealing with small claims.
Yes, only small claims
And
and judgment debtors.
Might I ask, do we do this in Baltimore City? How frequently do we do this in Baltimore City in small claims?
I do not.
The five zip codes that
I
had the
have seen it
highest.
done, but
It said, I don't see details or stats on Baltimore City, but it said the 5 zip codes that had the highest numbers contained 81% persons of color. So this is all in your testimony. I'm just pulling from the testimony to explain where this bill may be needed.
This is what the AG said. What we learned over the succeeding years since 2013, and when COVID-19 global pandemic has made clear, is that the use of body attachments to collect civil debt is not only questionable constitutionally, but it also is outdated, unfair, draconian process that hurts people of limited means and has significant desperate impact on people of color. And you'll hear from other witnesses supporting HB 848, only a handful of creditors' attorneys still deploy this harmful tool, often to extract assets that desperate indigent do not have. That's the testimony from the Attorney General's office. Now, I know, let's just get all three out. Delegate Fisher has been waiting, Delegate Grammer, so Delegate Fisher.
Have a comment anymore, Mr. Chair.
Delegate Grammer, thank you.
Thank you. So it's been an increasing problem I've heard across the board when you have like a plaintiff defendant scenario in court, that people are just bouncing from the situation, and it kind of gums up the whole case. If my concern here is that in eliminating a failure to appear scenario where you can bring them in, is it possible at all to require an interrogatory to be sent prior to executing this? That way you would try and eliminate this scenario from even occurring, rather than just eliminating the whole, failure to appear scenario. Is that workable at all?
Well,
That's usually what happens.
I was about to say, they have the right to do this in the interrogatories before.
Well, they have the right, but couldn't we just require these plaintiffs to do that first via the law? That way you can try and knock out.
The issue is that they will send the interrogatories, they will not be answered. So then they have to file the body attachment in order to get them into the court to answer the interrogatories. And what happens is the person shows up, the judge says, go with the attorney into my conference room, answer the questions, and then you can leave. And that's usually what happens, and it all works out. But the question is, the person, if he gets a summons and he does it, he shows up, that's fine. But what happens when they send the sheriff out to pick him up? And is that practice correct and right and appropriate?
So in
That's
these
really-
cases, it's assumed that someone sent an interrogatory, there was no response. They sent a summons, there was no response, and now they're bringing them in this scenario. That's okay.
Yeah.
Thank you.
Where's this AG's opinion? Where's that? Do I have the bill number correct? Because
It's not an opinion, it's his testimony.
what
It's in with the testimony of all.
do I have the bill number correct? What's the bill number?
848.
848. Okay, and it should be in there.
And Delegate Cardin, I'm just looking through some of this. I think this is connected to the previously, when we were talking to Bob Eden, with regards to, it says judgment debtors are entitled to that exemption, the 6,000, but a lot of them are not effectively able to defend themselves. So again, this bill is kind of circulating with the conversation we were having earlier, just to put everybody on the same base of why we probably got both of these at the same time.
Okay. All right. So I wanted to take a temperature and see where we are. I think that this bill is probably an easier bill than the other one. Only because it seems like the only people opposed the judiciary. And I have a feeling that we might be able to, Holly, you can check and see if there's any changes that may make it more amenable to them. I think that that's probably, but I wanted to see kind of where we were with it.
Mr.
And
Chair, I
yes.
think if we can figure out a way not to arrest people, but still figure out a way to kind of compel them to still come to court, I think that's probably the ideal scenario. I don't know.
How do you do it?
Wordsmith that, because I agree with Malone, like the current process is kind of intertwined with one another, but I think that would probably be the ideal scenario.
So what kind of punishment does the, because you can't fine them, that's the whole point, the reason they're there.
Right. You don't want to.
And you don't want to incarcerate them because you don't want to incarcerate people because they're poor. It's
Right.
just that they're not answering questions. So, it's an interesting issue.
Right.
Not an easy one. Okay. All right. Well, thanks. I mean, we will put that on our list of things to come back to. We have a lot to come back to, but let me just, all right. What is our next bill? 870. Okay.
Couple set of amendments, and I have not ran a reprint of them, but Andrew has the two sets and they're from the delegate. So Andrew, I don't know if you want to bring those up for Delegate Cardin.
Yes, I am doing that now.
$870.
870. This is this is a power of attorney in a bill that, if I remember correctly, let me just make sure. It's to expand, it's to clarify and expand the power of attorney act. Is that right? Holly, can you remind us exactly what the bill does? And we'll go to
Yep,
the
I'm
amendments.
pulling it up right now, so hold on one second. That's exactly what it does, Delegate Cardin. It just expands it says, it expands the Power of Attorney Act to include authorizations for an agent to perform acts necessary to assist the principal. So let's go through. I don't know what the amendments do because I just got those, so we'll have to
Okay, well,
break through those.
let's have a bunch of lawyers look at this and see what they say.
So it says the authorizations affected include regarding benefits from governmental programs, civil or military service.
So I'm gonna.
Who is the bill from? I know this is Delegate Hill's bill, but was it her idea or was there a party that was?
For the floor system.
Let's see, I'm looking. So,
I feel
The
like the
elder
bar,
law section, sorry for interrupting, the elder law section
yes,
of the
see, I
bar.
thought
Yep,
the
the
bar
elder law
association
section.
was supportive of the bill.
favorable with amendments, right?
Yeah,
Yes, elder law and the
Okay, so
estates and trust.
it's from the bar. It's from the bar, and if, I'm trying to remember back, I think that there is a lot, there's things that the attorney or the person with the power of attorney is incapable of doing,
So on the
because of the
form,
way that the,
delegate, I'll just help because I just found it. So right now, the form, the statutory form allows the person to name the agent and they can choose the powers. But the form does not allow a person to elect to have their agent facilitate these other decisions that revolve around public governmental benefits like Medicaid. I'm sure there are more. It's
Right.
going through all of the things that it adds. So it allows you to just add additional powers to your power of attorney versus executing another power of attorney.
got it. I now remember. So it really is, it's about facilitating this for, particularly for people in a vulnerable position. So can we figure out, can you help us figure out how the amendments impact the bill? Are the amendments, so the amendments specify what you can do, assist the principal in meeting the eligibility requirements and qualifying. I guess that's for different benefit packages, federal benefit packages, including obtaining
Yeah.
personal financial records to the extent authorized in the special instructions below to transfer gifts and principal property. That seems reasonable. Including obtaining personal and financial records to the extent specifically authorized below. Can you go down a little bit, Andrew?
Yes.
Keep going.
Second page.
Yeah. Okay, so I think that this all looks fine for me.
Mr. Chair.
Who did the amendments come from, Holly?
The sponsor and both sections of the Bar Council came together to make amendments. The second set, Andrew, we have two sets. It looks like the second set is simply clarifying some of the first set that maybe got left off. Just clarifying language. It doesn't look like there's anything big
Okay,
that's not in the first set of the.
Yeah.
So
Are they
I-
visible?
I just
Sorry.
want to make sure, Holly, that there's a bar, so when you say Bar Council, so the Bar Association, the Elder Care and Estates and Trusts Bar both helped draft and approved of these amendments that they will facilitate the work that they're doing.
Yes, and when she's testified on the bill, I don't think we had the amendments yet, but the bill, as we heard it in the hearing, included the amended language.
Right.
All right.
The only reason I say her testimony speaks to the amendments. So if anybody's looking at the floor system right now.
Is there anybody who has any questions about, this,
Delegate Conway,
the amendments or the bill?
his hand up.
I have my hand up, but it's.
Go ahead, Delegate Conway.
Why are we holding 8:48?
The chairman asked me to hold it because he was trying to, I think he's trying to work with the judiciary on an amendment.
Okay, thank you.
Yep.
Mr. Chair, I move favorable on House Bill 870.
As amended, so let's work on the
As
amendments
amended.
first.
I'm sorry, as amended, yeah.
So for
Do
only
we need to vote
amendments,
on the amendments?
is there anybody opposed to these amendments that were worked on by the bar and the sponsor? Okay, I don't see anybody who's opposed. and I'm gonna assume that everybody is in favor of it. So that's great. Now, the bill is amended. Delegate Williams moved favorable. Is there a second?
Second.
All
Second.
right. So I look for at the bare minimum today, guys, we are going to help our elder brothers and sisters in being able to deal with their estates, wills, and trusts. So isn't that great? All those in favor of the bill as amended, raise your hands. Is there anybody opposed? Great. Okay. Andrew, you can take the amendment off.
Okay.
Thank you. We got a second bill out, guys. That's fantastic. Isn't that great? 1250. Is that Delegate Fisher's bill? Which one? 1250.
That's Delegate Malone's bill.
Oh, move
That's
in
the task
favorable.
Move favorable. Move favorable.
Okay. Delegate Malone, do you want to
Where
explain
did
what the bill does?
I don't know if he's present with us
Oh,
right now.
He's not. Okay, well, why don't we hold that bill and go to the next one until he gets back. What's the next one, 1271?
Well, it's 1261, but we're going to hold that because the two sections of the Bar Council, real property and estates and trusts, are getting amendments.
Okay,
And they're starting the Senate. So as soon as I get the finalized amendments.
perfect.
Yeah, I just
Well-
don't want y'all to waste time if the amendment
No,
language.
no, we don't need to waste any more time. That's fine. 1264. Oh. Where are we? Where's, I don't know, 1264. All right, this is Delegate Fisher's bill. Delegate Fisher, do you want to talk about your bill? Or is she not want to?
I am here. I'm sorry, Mr.
It's
Chair.
all right.
I do want to talk about my bill, but which bill are we on? I'm sorry.
1264, requiring rather than authorizing the payment of commissions to personal representatives.
Yes, I believe. Holly, did you receive any amendments on this one?
Not on this one. I've heard that the bar is coming with 1261 and 12, the one that's in HGO for remote notarizations, 1265. But I didn't hear of anything on 1264.
Okay, I just wanted there to be
I think you're okay with this.
yeah,
one.
clarity. I just didn't want to do something and they were trying to. Okay. Basically the bill requires rather than authorizes the payment of commissions to personal representatives and their attorney's fees without the approval of the court under certain circumstances delineated in the bill in the administration of estates. I worked on this with Senator West. I'm open to people's, concerns and opinions. I would say that I think all the whole package of bills I represented to the committee and for this subcommittee's consideration all kind of basically came out of the COVID-19 experience for attorneys. And I would also say that I'm not, I do mostly criminal and personal injury. So I don't want to say estates and trusts is my wheelhouse. So it was definitely offered by the bar in good faith. And, this is seen, especially by the attorneys in this practice area, as something favorable. So yeah, I'm just open to discussion, Mr. Chair. I don't want to
Sure.
impose any,
I want to.
if that makes any sense. I didn't want to impose anything on them.
Is there a concern that there are times when a judge doesn't grant, an orphans court judge or a judge doesn't grant the compensation? That's question number
Yeah,
one.
I think that has been the concern. And if you look at the text of the bill, it's a one-word change, right? It's from may to shall. That's all the bill does. If you guys open it up. So I think there were those concerns. I am trying to recall. I see Dell Grammer's hand.
I got
Sorry,
Grammer.
I'll
I
be
got
one
you.
second. I'm trying to recall some of the testimony of things that happened within the last year that made it more of an issue as to why it needed to also be the shall, but I'm losing it in my head. But basically sometimes they don't, and it's just easier, even though it's typical. This would just, take away any confusion. So it's a
Okay.
one-word bill,
Delegate Grammar, what's
but it's
your,
up to you guys.
Yeah, I just wanted to get at the heart of that. Why has it been a may opposed to a shall? I mean, it's a one-word bill, but it's probably the most important word in the statute. Why is
Let me
it?
get away with something, Delegate Grammar. Come on.
so here's, I would think that the issue is, and maybe some of the other lawyers can get on, is that what happens when somebody, when a lawyer asks for their 9% or their, whatever it is, or their 1,800 plus 3.6%, if it's a bigger estate, and the judge says, you didn't do any work on this, you don't deserve that, I'm not giving it to you. I mean, that would be kind of, I would think,
Yeah.
why they don't, and then the lawyer says, well, I'm entitled to it, whether I did the work or not, and the judge's like, no, I'm not going to give it to you. And that would be, I think, the issue is, the judge can oftentimes, with the discretion, can see the quality of the work and then make a decision on what to grant. I would
And
think
usually,
that's the problem.
the attorneys go into it feeling like that's what they're going to get in the compensation. Do you know what I mean? Like, that's why they're.
So in these particular, so these are estates. This is typically a situation where someone has died, some assets are getting passed on.
And that's why Delegate Grammar was exacerbated in this last year, in a morbid sort of way.
So this could be a situation, some estates may have it spelled out how much a representative gets paid. Some don't. Is that?
No, it's in statute. It's in statute how much they're entitled to. In fact, if you look, it says, if the property is subject to administration is not more than $20,000, then the commission may not exceed 9%. So however, if the property subject to administration is more than $20,000, then the commission may not exceed 1,800 plus 3% of the amount over 20,000. So if your estate is worth, look at this. Here we go. We're like what we were doing earlier. Your estate's $1 million, right? Times 0.036.
Mr. Chair with the math.
Right? Equals 36. You get 36,000. You get $37,800 on $1 million estate. That's what you're going to ask for. And the judge is going to say, wait a minute, you spent 5 hours on this. I'm not giving you $36,000.
That's kind of the answer I was expecting. I appreciate.
I would think that's the problem. I unfortunately, I don't know if that's the problem or not. Delegate Williams, yeah.
I have a question. Even if we change this to a may, doesn't the court still have discretion on the dollar amount at the end of the day based on existing case law here in the state? So even though we say you may award attorney's fees,
You shall.
I'm sorry, shall award attorney's fees. There's still the existing case law that the attorney's fee still has to meet the reasonableness standard. And so I would think that would still come into play. So they can award the $36,000 or the court can award an amount less, but they still have to make an award. So I still feel like there's still some discretion that the court will still have, even if this bill passes.
Is this something we can ask the courts? I mean, I'm not opposed to the principle of the
Did
bill.
they, Holly, did they weigh in? I don't know.
Yes, so they're unfavorable. And I was actually looking at the testimony right now, and it speaks to basically what Delegate Cardin was bringing up, that
This bill would require rather than authorize with certain conditions the payment of attorney's fees and commissions. The judiciary traditionally opposes legislation that includes mandatory provisions. The judiciary believes it is important for judges to weigh the facts and circumstances for each individual case when making a decision.
But in current law, we already put in the minimum, though.
Delegate Fisher, I was just going to that point, and where MSBA got it is it only addresses the cases where the fees are equal to or below the statutory cap, which is what you were speaking on. And then only if all interested parties affirmatively consent to the fees. So it does not require approval. That's the only, it's very specific in that instance.
So only if all the parties agree that, yeah, you should get your $36,000, And then the judge says, no, I'm not going to give it to you.
Yeah.
That's when this would take.
Well, no, you wouldn't even have to go. The fees are then just paid out of the estate. If it's below a certain cap, a statutory cap, it's paid and it wouldn't have to go before the judge, which is why the orphans
Right.
court, they're also opposed.
Or the
But
orphans
here
court's
it
also
says
opposed?
sometimes all interested parties that consent in writing and the fees are all fine below the cap, but then they go before the judge and I guess there's issues of contention. I'm just reading the testimony that says sometimes they change that fee cap. So that was an MSBA.
I would like to know what's on Malone's thoughts, even though he just like walked away. So yeah, I mean, I will say that like, and like I prefaced my comments, which might not be great preference because of course everybody wants their own bill to pass and all of that. But I think, you know, to me, it sounded like a real issue, but I don't have the same personal subject matter expertise as others on this committee may have. I do think that an attorney, Go ahead, Malone. I was actually looking for what your thoughts were.
Yeah, I apologize.
That's okay.
Trying to multitask, and I apologize. This is part of my multitask. I reached out to one of the orphan courts judges in Anne Arundel County, and they said they almost always get done, but they said there are times where even when there's a consent by all parties, sometimes there's not a lot of parties, and it can be set up. There might only be two parties. Somebody may just want it over with, and it does need a second set of eyes. And there may be a time where they feel that it is appropriate to reduce the commission. Therefore, I'll be voting no, candidly, to support the orphans court judges of Anne Arundel County, one who is an attorney, and that's the one I reached out to.
This is from the Bar Association.
Yeah. We worked on it.
hate
These
to-
are literally the estates and trusts like committee.
I hate to even go here, but if we pass this bill, it's very likely that it would be more reliable and possibly even higher fees to the folks on that.
No, but it's in the fee structures in the statute itself, though, Brewer. It can't. The statute already tells you the minimum. Like if the property is not more than 20 grand, then the commission can't exceed 9%. We already put the guardrails in there for them.
Granted, the scenario I was thinking about was more along the lines of the situation that was just referenced, I think, by Delegate Malone. You have one or two parties that just want it to be done. Judge wouldn't necessarily give that high of a fee, but they're just like, we don't care. But thank you.
I just want to clarify at the end of MSBA's testimony, just because I mentioned it before, it does say, Delegate Fisher, what you were talking about before, the statutory cap. This only, it says the rule completely remains. It's just narrowing the situation where all interested persons have to consent in writing and the fees are at or below the statutory cap. If an interested person fails to consent, the rule would remain. It'd have to go before the orphans court.
The judge would still have the discretion, right?
Exactly.
I think Delegate Cox has his hand up, Mr. Chair.
Yep. Go ahead, Delegate Cox.
Thank you. I support the bill, and with all respect to Delegate Malone's comments, and I understand that as somebody who practices before the orphans courts on these estates, I like individuals having power over their own estates. I don't like the government coming in and dictating when everybody's happy. There's really no need for the government to come in and say, oh, well, guess what? We don't like that you guys are happy with this. We're going to say that this money needs to be reduced, or the personal representative. I had a case once where the judge, didn't like the personal representative having done all the work. And, we ended up getting the statutory amount, but it was just a pain. So I think, I like the fact that it has a catch-all so that Delegate Malone's comments are protected if there is not a consent from everyone. That would be my thinking. I'm going to vote yes.
Mr. Chair, I move favorable on the bill.
All right, I'm just gonna, before I take let me just tell you, I just got a text from our orphans court judge.
Ooh, they're watching us live.
What's that?
I said, ooh, they're watching us live.
All
Oh,
orphan court judges.
My organization is very much opposed to this. It takes away discretion from the judges to be able to look at this from a independent perspective. Practically, it's not a huge deal because it doesn't handle. I'm trying to read while she's texting. There are rare cases when it's important to make sure fees are fair given certain circumstances. And that goes to what Delegate Malone was saying. Also, the Maryland judiciary has stated they're opposed to it. Yes, we know that.
Yeah. Well, I mean, the judiciary never likes to give away their discretion. Their discretion is power. So,
Right.
I mean,
So
that's
I'm
kind of
more-
like a given. Not that I don't respect everyone in the
I'm more
ordinance
concerned
court
about the
or our
ordinance court
judiciary. I
not
do
being
very
able to.
much. But I'm going to second Delegate Will's motion.
Okay. So the motion is favorable and there's a second. Any other discussion on the bill?
Yes, I just want to be clear, the orphans court was against this, right?
The orphans court's against it. That's correct.
Yes,
Thank
Doug.
Okay. All those in favor of the bill? This is going to be a really interesting one right here. 1, 2, 3, 4. And all those opposed to the bill? 1, 2, 3, 4. Wow.
Wait, you didn't, Delegate Cardin, you didn't count Delegate Jones. It's 5. Or you did?
Delegate Jones, I did count.
Voted yes. That's 5-4.
Did she vote for it or against it?
Roll call.
Voted for.
Just
I don't
roll
think y'all
call
voted
it.
for it. She voted for it, Delegate Cardin. but you
Roll
didn't
call.
vote.
Just
Yeah,
roll
let's
Two,
call
Roll
it.
three,
call,
I
roll
counted
call.
Delegate Jones. We have
Roll call.
Yeah.
for the bill, Crutchfield, Fisher, Jones, and Williams. Against the bill, Malone, Conway, Watson, and Grammer.
You didn't count Delegate Cox. He was for the bill.
Crutchfield, Fisher, Cox, Jones, Williams. For the bill.
5-4.
Against the bill, Malone, Conway, Watson, Grammer. And if I vote against the bill, then it's a tie and it fails.
Uh-oh.
You're the chair. You're the subcommittee chair. Not me. Up to you.
I am going to vote against the bill and it's going to fail.
But we love you, Delegate Fisher. I'm sorry.
That's okay. I'm
We really
sad.
do.
I can't wait till one of you are in a bill.
This is not the one Delegate
you
Fisher
want it
cares about
over
winning.
with.
None of my bills get sent here, so you don't have to worry about it.
It's hard. When we see how that turns out, if the subcommittee
Absolutely.
would reconsider
So-
the Senate version.
So we can either
That's fine.
reconsider the Senate version or, I'm happy to reconsider this one as well.
I'll work on my arguments to be stronger as well.
And you got to make sure that we're not getting texted by our orphans court judge.
Yeah, tell them stop. They're not. I don't know about this like texting influence. I might make a motion for that to be considered, as we used to have subcommittee in person. All of these other elected officials were just like texting during subcommittee, but I'll leave that.
Mr. Chair, that's actually a great point Delegate Fisher makes. One thing COVID did change for the legislature is typically the public would not be able to see these voting sessions. And not only can they see committee voting, they can see subcommittee voting. So, I mean, the entire
That's a
public
good
has
thing.
much greater access to what's happening right now. And
They do,
despite-
but the public doesn't have like chairman's cell phones to text. So that I would say that's a bit different.
Granted, but they
House
can
Bill,
always email us.
House Bill 1266.
Move favorable.
Bill 1266 is Delegate Fisher's custodianship bill. Why don't you talk about that one?
Wait, what bill are we on?
1266.
Oh, 1266. Sorry. I'm just pulling up my notes and stuff. I think Holly, does this one that has amendments coming? Or no?
That's 1261. This one, as far as I know, is okay unless you've heard differently.
I haven't. I'm a little worried, but I'll look through my thing. Basically this bill, this might be a little, again, you guys heard my preface from the last bill, so I won't repeat. But basically the bill is altering the provisions around the custodianship and the deposit of wills by establishing duties and requirements, allowing a person to have custody of a will other than the testator, the person who made the will, or the testator's agent, and to deposit a will of safekeeping with a register of wills who are supportive and willing to do this, and authorizing an attorney to dispose of a will in a specified manner under certain conditions. I'm not going to repeat what I said in the last bill we just reviewed, but this came out of obviously just COVID, the online nature, and everything that's gone on for our society over the last year. I know my own, at least this I have experienced personally in a lot of ways in my own family with wills and where to go. It might sound sort of weird, but people kind of would think like, oh, I'll go to the register of the wills. There might be a copy of the will there. So I think the fact that the register of wills is willing to do this and enables people to hopefully have some clarity on custodianship. Again, I'm open to these committees' opinions. I know that Delegate Malone, Delegate Cox, Delegate Cardin, and Delegate Williams maybe practice in these areas a bit more than me. So just offering it to the committee. Again, the Estates and Trusts section worked on this legislation in a collaborative manner. Again, Senator West is my crossfire on these bills, and I just would
any questions for the delegate or any comments?
Mr. Chair.
Oh, wow.
I'll
Delegate
defer.
Jones. Delegate Jones.
Okay. So I'm just wondering, can you explain to me what the process is now? What about this bill makes it different from how the holder of the will has to operate currently?
Right. So it is my understanding, and this may be something for Holly to help us with, but it's my understanding that the Register of Wills is not a depository of wills presently. So you can't use that as a place to keep your will safe and sound in the jurisdiction where you reside. So they just don't have, and so what they're saying is we are happy to be that depository. Allow us to do that. That is my understanding of the bill. Maybe there's other comments, but wait a second, Delegate Conaway. Yes, Delegate Grammer.
I wanted to inquire about the disposal of wills. Currently, there's a prohibition on the disposal. Is that correct?
So, right. So I believe that if you are an attorney, you are not permitted to dispose of the will of a person.
Period.
At all, right? You're not.
I think there's a lot. I'm just looking at the testimony right now from MSBA. It says there's really little guidance. So it gives an example for disposing of the wills. Right now, you're not allowed while the testator is alive, but you don't necessarily know. So it goes through. It says because people frequently lose their wills, it's customary for the original wills to be stored with the attorneys who prepared them. However, current law does not provide guidance with respect to what a holder of an original will may do or must do with that document if he does not know where the testator lives or whether the testator is still alive.
So clearly there's, not much value in a will after it's executed, but can somebody who practices speak to, is there any value at all in having these recorded for posterity, or is it just, hey, that we're done with this? 25 years passes, we're good.
Well, my concern is the mandates against attorneys in the bill. I know the bar section was for it, but as someone who practices in this area, I don't like being told that you have to send a will to the Register of Wills, because a lot of my clients don't want to do that. It is suggested under the statute now, and it's a $5 fee. So some people do that, but a lot of times especially with trusts, when you have a pour over will that includes a trust, you don't want that going into the public records, even though it's supposedly sealed. We all know that that may or may not be the case. So that's the only concern I had. And then also destroying the will. I mean, a lot of times when a testator issues a new will, it eliminates the old will. I know the bar council said that they didn't think this would prevent destroying the old will, but I was a little concerned that it might not expressly say that. But other than that, I mean, I can see that there's benefits to trying to provide some clarity for when the testator is no longer living and you've got, or you don't know the status, and you've got, wills that you discover that are 25 years or so, or less than 25 years, and you can't find the party. So that provides.
Bless you.
Thank you.
Delegate Cox, so you wouldn't see any problem after 25 years with just being rid of it?
I'm reading it, and it's a little confusing. I think it says that an attorney licensed to practice law in the state may dispose, if he has custody of she or he has custody, the will may dispose of the will if at least 25 years has elapsed. And you diligently search and you can't find the person. So it does provide some clarity and protection in that capacity. I wouldn't be opposed to that section of the bill.
And it says may, they don't have to. It's just.
Right.
So they're not required, by the way, to send it to the Register of Wills, are they?
Under this bill, I think it may require that. Under the first.
No, they're not required to. It gives them the option. For example, if you were retiring, or if another attorney was taking over, I guess, and had to just dispose of the wills, it gives you an avenue. But I think it's an option. It's an option. It doesn't mandate it.
Why do you think it's a shall, Delegate Cox?
It says.
Where?
Okay, so it's a shall deliver the will. I thought it included to the register, but I'm not. I think Holly's right. It's a separate section for that.
I think Delegate Crutchfield has her hand up, Mr. Chair.
Delegate, I'm sorry, Delegate Crutchfield.
Yeah, I just had a quick question for Delegate Cox, because you mentioned trust.
Then Delegate Conaway, I apologize. Yes.
Yeah, you mentioned trust, and I didn't think that trust needed to be ever filed with the Register of Wills. Is that correct, or?
Correct, but I just don't like it when you have a trust and you have a correlating will. I wouldn't want to send the will in.
Well, yeah, I mean, usually that's how they're commingled, right? But I mean, as far as I know, the trust would stay with the lawyer's office. So you wouldn't really need to do that. So, okay. All right. I just wanted to make sure I understood it correctly.
You're not, and you wouldn't be required to send the will to the Register of Wills. You would, but what happens when you have the trust and the will, you don't know where the testator is. You've lost him. Now what do you do? All right, Delegate Conaway, you're done. Delegate Malone, did you have a comment?
I did not.
Am I allowed to move my own bill?
Sure. I think Delegate Williams has a question for you.
I mean, I was going to move the bill for you, Delegate Fisher. So I just.
Look at my county mate. She's just.
And I was just going to say, I appreciate.
I'm wearing the same color today.
Anyway, I appreciate this bill because we had an attorney in my office back in 2019 who got like really, really sick. His appendix burst. He had it was just a whole situation, and he was out for like 6 months. And then because he almost died, decided he wanted to retire and move on with his life. And so I remember just kind of dealing with how do we deal, because he did some estates and trust stuff, like how do we deal with all of his cases? And anyway, so it just became a little bit of a thing. And so I appreciate this bill to make it easier and clarify kind of the process when these things do occur. So.
Second, and I think you were right.
All those in favor of the bill, no amendments. All those in favor of the bill, raise your hand. one, Crutchfield, Conaway, Malone, Williams, Watson, Fisher, Cox,
I'll go ahead.
Grammer, Carden, unanimous. There we go. Done. All right, so
Yay, got one, everyone.
And-
All
For everyone
right.
watching out there.
we killed Delegate Malone's bill when he stepped away, right? No, I'm just kidding. Let's go back to Delegate Malone's bill. Do you want to talk about your bill, Delegate Malone?
I'm not going to say much new that I didn't say during the bill hearing, but
Remind us what it does.
What I said during the bill hearing is.
What's the number, bill number?
House Bill 1250.
Thank you. It came to my attention a couple years ago when I introduced a bill regarding intestate, the passing of an estate when there is no will, and what happens. And it was discovered that Maryland's laws are not matching what most of the nation is doing. So I spoke with Professor Valerio, and she said, yeah, we're kind of out of sync, and suggested that maybe there'd be a study done to bring us in sync with more modern times of how to handle things. And once again, it's a study. That's the quick gist. I'm not saying it's the most important bill of this year. My slight fear is next year, we almost never like to do studies in election years. So do we run a risk? Do we run a risk that if it's not done this year, it's not done next year? And then there's some people that get hurt because it never gets done.
Delegate Malone, I'm sorry. What's your bill number again?
Okay. Yep.
1250, I think, is what Holly said.
I have one quick question. Did you?
1250.
One quick question for you. The membership of the task force, was there ever any question as to, you have like a member of the House, a member of the Senate, and an orphans court folks, and then somebody from the bar. Is that sufficient? Do you have any concerns?
I'll tell you, I'm glad you brought that up. The one thing that was brought to my attention is there probably should be an amendment done to add somebody from the Register of Wills. So I don't know whether Holly could do an amendment to just add somebody from the Register of Wills.
Yeah.
Wait,
Would they
before you go anywhere,
participate?
Delegate Williams.
But would they participate? Because I know typically when we do work groups and we add in the judiciary always says, oh no, we don't want to participate because of separation of powers.
Well, Register of Wills is not really part of the judiciary.
Okay.
Mark's in the waiting room. Can you see that?
No, I don't see it.
Click. Did you click participants at the
Their
bottom?
budget, so Delegate Williams, their budget is actually comes out of the judiciary, but it's self-funded. So it's not, they're technically not a part of the judiciary.
Okay. I mean, that was my only
And
question.
that's good. It's a good point, Delegate Williams.
To Delegate Malone, I want to point out, because I drafted this legislation and we put in, if you remember, 3 additional members, if the chair should elect, just to open up that door in case they needed additional people to study because the issue hadn't been studied for so long. So your look in subsection C, we have the chair of the task force may appoint if necessary and deemed by the chair. So I'm happy to draft an amendment, but there's also that window.
And I hear you, but because the Register of Wills is sort of the boots on the ground for getting estates done. They're probably one of the more important groups.
Sure.
Yeah,
I had a question, Mr. Chair.
We could also, 1 second, we could also do is uncodified language to say that one of those people that the governor should designate could be, or that the chair can designate should be from the Register of Wills. Do something like that. And then, do you have to do an official amendment for that? I guess you do. But
Yeah. Anyway,
yes, Delegate
if the
Fisher.
subcommittee wanted, I could easily put it in. I just wanted to point out that there's that window too, just in case.
Yeah, I appreciate Delegate Malone's bill, and I'm supportive of the bill. I just wanted to ask about the part of like where it says one representative from University of Baltimore or like Maryland School of Law, Carrie, like how do you decide if it's or? And then I just wanted to put it out there for Delegate Malone. And I don't know if something like, I don't know if J. Franklin Bourne Bar Association, one of the bars or something, I just would just make a point about the diversity of this task force. And I don't know how, like it could be, but you don't really know from the way the membership is delineated in the bill, if that makes any sense. but not a big deal, but I just wanted to point that out.
And I hear you, and I'd be open. It's one of those things. My biggest concern regarding my own bill is who's going to step up and be willing to do the work. I would admit it's my biggest concern. I think it's needed, and but for the fact that Professor Valerio basically sort of volunteered to be involved, but I don't think it should be a one-person show. So, and most of the rest of the suggested members came from Holly as the draft writer, as I recall.
So,
I just looked at some of the former ENT related bills and kind of pulled from that. But again, based on the library, we don't have a lot of research on it. So that was one reason the 3 members were brought in. The last report, I think, was from the 80s. So it is an issue that hasn't been touched upon.
let me recommend the following. Number 1 is we draft a simple amendment to include a member appointed by the Register of Wills. Number 2,
Association,
let
whatever
me, wait, okay, oh, I'm just getting a text right now from Andrew saying Michaela Muffaletto, I believe she was someone Delegate Fisher wanted on, is in the waiting room. Should she be let in? Do you want her
Yeah,
to be
she's
let in?
my expert that I had, but I tried to defend those bills on my own. Which
You got the bill. You got the bill
one
passed.
out of 2 is good. I don't know if I have another one pending, Holly, at this point.
We'll and the other one, you know, we'll look and see what happens with the Senate bill. Okay. So no, Andrew, you don't have to let her in at this point. Okay. So we draft the amendment, adding the additional member, and you could add language. I'm just suggesting this, Delegate Fisher. Add language into C2, line 9 of the bill. The chair of the task force may appoint up to 3 additional members to the task force as considered necessary or to appropriately reflect the diversity or ethnic diversity of the state as appropriate by the chair, something to that effect.
Yeah, just a line like that would be great so that when they're considering it, you know, I just wouldn't want a task force that had no
I'm
diversity.
absolutely good.
And I don't even mean, you know, racial, gender, whatever, you know, so just a line that it could be considered when they're picking the folks. That would be even for like the Senate appointment and the House appointment, you know, just making sure that that's a part of it.
Maybe
Is this
appropriate-
cross-filed, Delegate Malone?
Huh? It is not.
Is this cross-filed?
It is not.
I'm sorry, what? No?
It is
Okay.
not.
Good.
This idea,
That's fine. I just want to make sure because
it actually came to
That's
me
fine.
after the bill hearing. This was a really early bill hearing, and that's when the idea came to me.
okay, good.
I misspoke. Professor Valerio asked me to speak to her class, and that's when I got the idea for the bill, which was after session had started. My thinking on the diversity is maybe appropriate diversity. If we say ethnic, then it, and once again, I love to see strong diversity. My biggest fear is mostly how hard will it be to find enough people to staff this group?
Okay. Is there a motion on the amendment?
I move favorable on the oral amendments outlined by our chair.
And assuming that they're non-controversial, we can review them. We'll accept them as committee amendments. Okay. Is everybody in favor of the amendments? Hands by raise of hands. Anybody opposed to the amendments? Okay, Delegate Cox is opposed to the amendment.
No,
All right.
no, I'm not opposed.
Oh, he's not
just
opposed.
slow.
He's
No,
just slow.
my screen froze.
Watch out, screen freezes, you vote against the bill. Okay, all those in favor of the bill, is there a motion?
Move
So
favorable.
Second.
All those in favor of the bill as amended? Is there anybody opposed? Delegate Cox opposed? No, just kidding. Okay. All right, good. Is there a bill that we held earlier that we can go back to? We're not going to do the SLAP right now. I just don't, we don't have the time. But is there another bill that we held that we didn't have time to discuss? And I'll try and do this in like 10 minutes and then we'll be done. It was either 308, 405, or 766. I don't remember. I don't know what those.
308 is the slap suit. 405 is the Ways and Means expert witness attorney's fees for special education. 766 was the I believe that was the one Robert Enton was with us on.
Right. Okay.
Or no, that was 772. 766 is the administration of estates, the fee structure.
Oh, right. Do you want to try and work on that one? Did we get any answers as to, or did anybody have any thoughts as to changing it from a percentage to a specific amount? Is there concerns about, I know that we have, some disagreements on the subcommittee. I just want to see if we can work on that. Yes, Delegate Kramer.
Thank you, Mr. Chair. I don't have I actually like the idea of moving away from percentages to specific amounts. I just have a general concern about the bill is ultimately to raise fees, it seems. And if it were simple and it just said, hey, let's strike the fees for the people who barely, hit those lower dollar amounts. I mean, I think that's nice and simple and non-controversial. I don't think it's a great time to have put in place a progressive fee structure, which ultimately raises fees.
Okay, good. Delegate Williams.
Mr. Chair, I hear and respect Delegate Grammer's position, though I would respectfully say I kind of disagree, especially as it relates to the smaller claims. I mean, one of the reasons why this bill was put in is to reduce those fees, especially on the majority of the people who do have estate actions, which are on the smaller claims. And I think Holly has stated earlier today when we were meeting, I guess roughly about 90% of all of the estate claims fall within something of like $750,000 or less. And so since this bill proposes to reduce the fees on those individuals, especially as we're seeing, unfortunately, our mortality rates increasing because of the current pandemic, I think it is imperative that we try to do something for the little people who are struggling during this financial challenging time.
I actually agree with that wholeheartedly. I just don't think in reducing fees, I don't know if we need to do both. We could just do that and thumbs up and move on. I just don't think we need to.
Delegate Cox, and I know Delegate Cox had an issue with whether this was going to reduce monies going to the coffers of the state, right? That was one of your issues. But go ahead, Delegate Cox.
Yeah, and I just would echo Delegate Grammer said, and I agree with Delegate Williams. Let's reduce fees for the little guy, but let's not pretend that we're not raising taxes here on the state. I don't think that's a good message at all.
So there was nobody opposed to the bill, by the way. Just FYI, nobody came in opposed to the bill. Taxpayer Association of Maryland or whatever did not come in and oppose the bill.
I wouldn't say that necessarily is an indication of acceptance. I mean, a lot of these bills slip through, honestly.
Honestly, I didn't even understand the bill until I got down to the nitty gritty of it. The average person most assuredly isn't going to catch something like that.
So I'm just gonna, so you are reducing the fee on 80% of the estates that are administered. And you are increasing the fee on and you're keeping it the same, pretty much, essentially the same on what was it, 10% or 14%? And for that top 10%, or 9% is what you're increasing it to. And one of the comments from Delegate, I think Delegate Grammer was trying to say artfully before, was that if you incentivize people to move their estate out of the state because they're going to be paying these huge fees, then you're going to lose all the money. You're going to lose the estate tax revenue as well. That was, I think, the most compelling comment that I heard. But I'm just looking. So if you have a $2 million estate times 0.002, which is the amount. So it increases from a $2 million estate goes from 1,500 to 4,000. But they are not moving because of an increase in, they're not going to pick up and leave because of an increase of $2,500. They're just not going to do that.
Yeah, but Mr. Chair, it's always just one cup of coffee. I mean, how many times have I heard that over the last 7 years? That's just one cup of coffee. It's a lot of coffee.
Well,
And-
my point is maybe there's some sort of cap on the much higher estates, so that if you have a $20 million estate, which by the way, if you have a $20 million estate, they are using very shrewd, smart estate and planning lawyers to reduce the amount that they're going to be giving. And so they're going to figure all of it out and make a decision based on, where they're going to do best.
But I wouldn't even, if I'm pushing the policy argument, I wouldn't even take it there. I would look at like line 8, something that's probably going to apply to people like me. I'll probably fall within $500,000 to $750,000. And at the end of the day, when you're like calculating those end expenses, I mean, someone's going to show you what it costs to retire here in Maryland, and that's what folks are going to be looking at.
But you'll be in the lower rate though, Delegate Grammer, under those amounts.
No, I'll be paying more. It's mine would go up to
$750 to $1,000.
Yeah,
Go up $250.
so I just think
You're going to move out of Maryland for $250?
No, but I think when people look at the totality of it, they're not just looking at that.
I don't have a problem with increasing the rates. The concern that I had that you raised, which, by the way, I'm not opposed to passing this bill as is. I'm just putting it out there. What if you said, it's 0.2% until you hit, 10 million, and then it's 0.1% after that, or something like that. Then you really are reducing the amount of that increase. It's no longer a progressive tax.
It's already a progressive tax. This just makes it.
I'm trying to throw you guys
it's already progressive. It's raising it beyond the intent of the bill. That's my problem. And look, I'll give you an example. There was a bill a couple years ago that the fiscal notes showed it was like a $4.50 increase on every person in the state's energy bill every month. It's $4.50, but it's $4.50 on everybody's bill all month. And nobody's going to look at that $4.50 and say, well, I'm out of here. But over 2 decades, somebody's going to say, geez, the cost of living here is skyrocketing. And these little nickel and dimes they hit you with. I mean, how many of these have we seen in the last couple of years? And that's my concern.
Look, these rates, you're not increasing these rates onerously until you get up to plus 5 million, in my humble estimation. That was the same. That's my take. Yes, Delegate Conway. Let's let Delegate Conway talk. You and I have been conversing.
Yes, I agree. I agree with Delegate Grammer that it's not just this one thing, but you take this one thing here, then you add on a tobacco tax there, then you add on another little tax here. When you put the whole package of taxes together, that's when you have a problem.
Well, again, you're paying a fee now. Now you're paying $2,500, and the question is, do you increase it, and how much do you increase it? I'm looking at just the 5 million and above, because everything else is perfectly, as far as I'm concerned, is well within reason. That's my personal. This is Delegate Card, not Chairman Card. Yes, Delegate Cox.
I don't think that's the question per se, Mr. Chair, because we could just simply do what would be best for the little guy, eliminate the fees for those that are being proposed to eliminate them, but take away the controversy of raising fees right now during this pandemic ending. And when everybody's, already having so many struggles, we don't need to have that optics or burden on the people. We could just, pass this bill with lowering fees. That's going to send a big message, and it won't hurt anything.
Can I make a motion, Mr. Chair?
Well, wait a second. So they're talking about the amount that this raises is about $1 million. That's what the estimate is. Just about
1.3?
1.3 million, right?
Yeah.
Okay. And it doesn't increase over time. It's just that is going to support, that's basically supporting the Orphans Court and the Register of Wills, I'm assuming. Is that fair to say?
I think it does increase over time. I mean, that's a 1.3 million by the enactment date. So every year, that's going to be another 1.3 million, I think.
It
Every
looks like the
fiscal
net
note-
effect is 1.3 million each year.
Every fiscal note increases over time, though, on every bill. If
I'm not gonna, you know, we can,
Can I make a motion?
you can make a motion. Your motion's probably gonna fail, but you can make a motion.
I
right?
understand. I'll make a motion that we leave the reductions on the low end and we strike the increases on the high end. Holly, can you oblige that if this passes?
Yes.
I'd
Yeah.
like to
Second.
move, I'd like to make that motion.
Second.
My man.
All right.
Roll
All those
call.
all those in favor of the motion, raise your hands. 1, 2, 3, 4. And
5.
Delegate Jones, are you a yes or a no? You're a yes? I'm sorry. Yeah, I know, I got the rest of you. I just didn't know. Delegate Jones, are you a
Sorry, I had
yes
to
or no?
mute because my kids are being noisy. Yes.
You were a yes.
Woo!
All right, the motion passes. Okay. I'm gonna make a motion. I'm gonna make a motion that we keep, here's my motion. We keep everything the same as the bill indicates up to 500,000. So it would be a decrease for people between 100,000 and 250. It would stay the same for people between 250,000 and 500. My motion is to increase the fees for people between 500 and 750 to 1,000. Increase the fees from 750 to 1 million to 1,500. Increase the fees from 1 million to 2 million to 3,000. Increase the fees from 2 million to 5 million to 4,000, and increase the fees for 5 million plus to 7,500.
That's
That
even
would be-
worse. That's even worse. Because not only would it undo the amendment we just did, you would create an additional tier.
No, I didn't.
Yeah.
It's a step in the
over
right
5 million.
direction. I feel like it doesn't go far enough.
You're creating an additional one.
Okay, I'll just leave it at, so you're saying so just leave it from 2 million to 5,000. Fine. We'll just leave it at 5,000 for that.
Point of order, Mr. Chair.
Yep.
The other motion already passed.
I know. The motion was to get rid of the fees under these fees, the fees that were proposed under this bill. And I'm making a motion to increase the fees, but just on 1, 2, 3 categories. 3 categories.
But I thought that was what the motion was saying no to that already.
No, the motion was to, my understanding was the motion was to keep what the bill says, which was reduce the fees for everybody reduce the fees to 0 for everybody under 50,000. Right? And then to not have any fee increases on anybody else.
The motion was to keep the reductions and remove the increases.
Right, okay. I understand now. So
So
you,
Delegate Carter, I'm sorry to interrupt, but I have another lovely housing meeting. So can I draft this up and we
you have another
look
meeting you
at
have to go
this?
to 5:30.
I'm happy to draft up, and then we can play with that and see.
I will do a better job, more artful job of making a new motion that
Okay.
will be very concise and will not contradict what Delegate Grammer's motion did. Okay?
Thank you.
All right. Very good.
Thank you. I'm sorry,
Good.
everybody.
See you guys tomorrow.
Sounds good. Thank you.